Todd Graziano is in the studio with us, the executive director of the Pacific Legal Foundation's Washington, D.C. Center and PLF, Senior Fellow for Constitutional Law. Oh, Pacific Legal Foundation. Yeah, I was going to say a new acronym for me. PacificLegal.org/DC-Center is the website. Todd, welcome back to the program.
Thanks so much for having me back.
Nice to have you with us. It's interesting. Last Friday, I think it was, on our TV show, I had a debate with Chris Allman, a conservative commentator, and she was like, the EPA wants to regulate puddles in your backyard. And I was like, no. And she was like really insistent on it, and I thought, this can't be. Tell me about this.
Well, I wish it was.
You're the guy that she was quoting.
I wish it was just puddles that they're trying to regulate. Under the Clean Water Act, EPA and the Army Corps have jurisdiction to regulate discharges into navigable waterways. That's
right, like the Mississippi River.
Yeah, in 1974, their first correct interpretation of the statute was that it was, barges and commercial vessels. Right. But shortly after that, they began to go awry, and they've run into two Supreme Court cases, including one the Pacific Legal Foundation won, that tried to limit their reach. But now, under a proposed rule that they're considering, not only do they regulate ponds that are only full of water part of the year, but they even want to regulate dry ditches. We had a case where in the desert, most of the year when it rains, the rain just soaks into the desert, but a couple times a year, a ditch will carry it, an arroyo, they call it in that part of New Mexico,
right,
will carry the water to another ditch, which will carry it to a dry creek bed, which will occasionally go into the Rio Grande. And they told these people they couldn't clean trash out of their dry creek bed. So under the proposed rule, there's almost no area of land where water might fall and might flow into some other stream that the Army Corps of Engineers and EPA doesn't claim it could regulate.
First of all, I want to get into the details of that, but before that, isn't the theory behind that this may be an occasional waterway, but it's going to end up in somebody's waterway, and that's somebody else's drinking water?
Well, there could be a lot of theories, but what's clear from the two Supreme Court cases, including the Rapanos one that Pacific Legal Foundation won, is that the statute only allows them to actually regulate the navigable waterways themselves and some very sensitive adjacent wetlands,
right?
But not these other lands. But more importantly,
you and I would probably disagree with this. Then I'd say let's change the statute. Let's broaden it.
Good point. But that would be unconstitutional. So that's the second point that Pacific Legal Foundation, because as the Supreme Court correctly found in NFIB case versus the Obamacare case in Lopez and Morrison, there are limits to the Federal Commerce Clause. You can't just come up with a sort of chaos hypothetical link. It can't be too attenuated, is what the Supreme Court said in the Morrison.
You just do it under something other than the Commerce Clause.
Well, if there is some sort of constitutional authority, perhaps, but the kind of regulation...
Article 1, Section 8, what's in the best interest of the public?
There is no best interest...
The general welfare of the public.
There is no... General welfare clause is part of the preamble. That's not an operative grant of power.
It's also in Article 1, Section 8. I'd be glad to read it to you.
But Article 1, Section 8 has a number of enumerated powers, and as the Supreme Court in Lopez and in subsequent cases said, if any one clause would swallow up the others, it must be an incorrect interpretation.
But that's not what Hamilton said. I mean, Alexander Hamilton, I encourage you to go back and read his 11-point plan for American manufacturers. I mean, there's a whole long preface in there about the reason that we put the general welfare into the Constitution was because we wanted to have the broadest possible power for government because we have no idea what future generations are going to confront.
There was a great debate between Federalists and Anti-Federalists, and Hamilton, of course, wanted more government, and Patrick Henry...
And he won. At the time he wrote this, he was George Washington's Secretary of the Treasury.
They all agreed that there were serious limits, and all of them would be rolling over in their graves at the kind of theory that you would read into the Constitution.
I disagree, respectfully, but none of them are here to speak for themselves. Here's back to your point about... I have the regulations right here in my hand, and I'm going to hand them to you in a second, and maybe you can point something out to me that I'm missing. It says, under the proposed first section of the regulation, Section 8, the agencies proposed to define, quote, the waters of the United States for all sections, and they go through 301, 311, blah, 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 blah. that all waters which are currently used, were used in the past, or may be susceptible to use in interstate or foreign commerce, right? That's including all waters which are subject to the ebb and flow of the tide, all interstate waters, including wetlands, territorial seas, impoundments of a traditional navigable water, tributaries, waters including wetlands adjacent to, and on a case-specific basis, other waters, including wetlands, provided that those waters alone are in combination with other similarly situated waters, include wetlands, included in the same region, have a significant nexus. And then they say the opposite. Then they say, or what is the opposite? They say those waters and features that would not be waters of the United States are, and this is where I don't understand what you and what Chris were saying, would not be regulated by this, would not be under their purview, are, and I'm quoting, waste treatment systems, including treatment ponds or lagoons, prior converted land, cropland, ditches that are excavated wholly in uplands, drain only uplands and have less than perennial flow. There's your occasional ditch. Ditches that do not contribute flow either directly or through another water to a traditional navigable water, interstate water, the territorial seas, or an impound. The following features: artificial irrigation, artificial lakes or ponds, artificial reflecting pools, small ornamental waters, water-filled depressions created incidental to construction activity. There's your puddles. They're saying none of this stuff is regulated. Groundwater, including groundwater drained through subsurface drainage systems, and gullies and rills and non-wetland swales. What am I missing? Where is the puddle in my backyard?
Well, it was included in the first section you read. The exclusion that you read is actually, I think, much more limited than you imagine. Remember, it said only ditches that are in uplands that actually never have water that could possibly flow downstream or reach are in this exception. This exception actually shows how amazing for those who know how to read,
what they're saying is water that can't contaminate other water, we're not going to regulate.
Yeah, what's
wrong with that?
But the other exception, the coverage section that you first read said, and any waters on a case-by-case, for example, any tributary includes any dry creek bed or any creek in your backyard or in your neighbor's backyard.
They say that have a significant nexus to a traditional navigable water.
As part of what you also read is they also believe in this aggregation theory. What they look at an ecoregion. An ecoregion could be all the Central Valley of California, hundreds of thousands of acres of the Great Plains. If the Swank case in the Supreme Court said they cannot regulate prairie potholes. But what they say is if you look at all the prairie potholes in the Great Plains, and if all the prairie potholes in the Great Plains are significant, then we can regulate any prairie pothole in your backyard, except for ornamental ponds that are on uplands, which has a particular legal context that doesn't make it very meaningful. The problem with that interpretation of the statute is, of course, that it violates other parts of the statute that says most waters are to be regulated by the state. And the EPA and Army Corps, think about the Army Corps' basic duty on navigation is to keep navigable rivers open. Yeah. To keep navigable rivers open. That's the only authority. So this rule...
Well, that's the Corps. This is the EPA. The EPA is supposed to protect the environment. It's the Environmental Protection Agency.
Correct.
Why would you not want the environment protected?
In this act, well, the states are doing a great job and being frustrated in their efforts to protect the environment. But the bigger...
I think they're pretty effective. When we were off the air, I mentioned I used to own a bunch of land in Vermont. And we had a swampland and a pond and a river that ran through it. And boy, was the state all over us. I mean,
sure, state, that's my point. The states do take environmental protection.
I think that's a good idea. I mean, my river and my swamp and my pond was downriver from somebody else's. And if that guy had decided that he was going to dump 50 gallons of benzene, like Koch Industries has been doing, I guess that's their new thing with Flint Hills, it's going to end up in my yard.
That's what Congress has declared in the Clean Water Act, that most waters are to be regulated by the states and certain waters are to be regulated by EPA. And if EPA would stick to doing what it's supposed to do and not interfere with property owners' other liberties.
How is this not supposed to be? You're as a property owner, your individual liberty ends when the water runs off your property into my property. I mean, isn't that a variation on my right to swing my fist ends at the end of your nose?
From what I hear from you, your theory is if there's anything I don't like, it's the federal government's authority to regulate. But again, the federal government doesn't have constitutional authority, but particularly in this act, EPA and the Army Corps only have authority to regulate navigable waterways, not things that might eventually affect navigable waterways. They can only regulate discharges into navigable waterways.
That's the Army Corps. That's not the Environmental Protection Agency.
They have the coextensive, the same jurisdiction. The same clause in the Clean Water Act applies to both of them.
Then we can agree that we need to change the statute, and I'll say we need to make it more strict, and you're going to say we need to make it less strict.
I think its original 1974 interpretation is just fine with me. But even if we wanted to go a little further than what you want, we would have to be mindful of our constitutional limits on the federal government.
Yeah. Is this not, I mean, all this Sturm and Drang about the new EPA rule, is this not being driven by basically polluting industries?
Not at all. It's being the great concern is from thousands of farmers. Those are the people who the Pacific Legal Foundation tends to represent.
Farmers produce some mind-boggling pollution.
Remember I told you about our clients who had that dry Aurora? They were just trying to pick trash out of their dry Aurora. There's another farmer.
Todd, we gotta wrap it up. Excellent. Thanks.
You're listening to the Thom Hartmann Program. Visit ThomHartmann.com for audio and video archives.
Todd Graziano, Executive Director of the Pacific Legal Foundation's Washington, D.C. office, pacificlegal.org. Thank you, Todd.
Thank you.
Thanks for dropping by. Good talk. We'll be back.